On our prayer, it was listed on 17th 11, but our names were not shown. So in that manner, case was not represented.
Now, only
There was 127 prayer petition we will make before the court below. The matter can be discussed tomorrow.
tomorrow, no, it's Monday.
But so I pay for listing of the I on Monday.
Monday, I for what?
I for pay for getting in a criminal. So this is a matter. So it's a political matter. My lord, the matter is for the maintainability of the petition. My lord,
What is the stage?
the state of mandatory notice has not been yet.
First, no, motion notice not issued. Yes.
I want to place two more judgments in series matter. May I place that?
Let the matter be started.
And one more prayer is that if Lordship passed the addition to pay the maintenance amount to the petitioner Lordship, subject to condition that he shall not be, coercive action should not be taken against him. But when he went to the family
Which case?
in another case, Lordship, so that case may be read. Family court is allowed to deposit him the amount.
I'm not getting anything.
Lordship, orders matter, Lordship may take up tomorrow.
Not tomorrow.
Because that is fixed in the next week. Lordship order is
Next week when?
next week on 7th, I think.
What kind of order do you need?
They stated that specific order should be there. From this month, you have to pay the amount. But there is an order, there should be continuation of the amount, if the order reflected like that is well. Tomorrow, if possible, time permits.
Item number 29. I may be now report.
Being on record what? Being on record justice service. Have you taken justice service? Now you want to bring on the affidavit? Yes.
I pray for listing of a matter for admission.
When? Notice served.
No, my lord. Yes, respondent have appeared.
Give a date next week.
6 months
Also, me give a date.
or 7.
13.
May I believe that mention for a listing of a criminal. Here, okay, then cross. Monday.
At what stage?
Evidence.
Huh?
Evidence.
No. Here.
Admission.
Notice served.
Yes.
When Muslim? A criminal petition. 8 of December. Yes, that is. Yes. Yes, please.
I am praying for this criminal petition, my lord. Because due to paucity of time, it could not be taken up on my 21st of November.
Give a date. Yes, sir.
The time of
At what stage? Bail hearing. Regarding bail hearing in NDPS. 10 copies.
10 copies are already there.
But you know our limitation today. Second half, I do not think anything will happen. So whatever you need to do, you'll have to do in the first half itself. Yes, madam.
Item number 33, my lord. Second application, my lord. Lordship sought for the CP, CDA, along with CDR details up to date, my lord. I have incurred, my lord. My friend has told me, my lord, that old CD is there, my lord, and along with the CDR report, can it be stopped, my lord?
We'll call it. It will not take much time.
My lord, definitely.
We'll pass it.
My lord.
You just ask somebody to be here.
I'll be here. Lordship, mention one criminal petition lordship for district for hearing lordship. Has been district since May, lord, 2018 matter.
What is the status? Service complete?
Service complete. Pending in hearing stage. Hearing.
So I mention it in the orders column. Then we'll see. We cannot direct it to be listed in the hearing. It will have to come first in order.
So it's got to take a
Do you think that before vacation, revision matters will be possible to be heard? Anyway, take a chance in list, mark it as orders. Give it.
Lord.
Fifth.
my pleasure.
Yes.
That's my prayer for listing two criminal petition electronic maintenance that pending for long days time for the wife on any date agree
What's the
for it.
11.
Another prayer that's also to be active.
All 11. Look, your vote is on 11.
May I please, I beg to mention item number 38. Matter may be adjourned for today, Lord,
Okay.
with the consent of others.
Yes, adjourn. List in the month of January. On the prayer of petitioner or respondent.
I am for the petitioner.
My pleasure.
Obliged, Lord.
For the 4:30 replication.
Tomorrow, Monday.
May I please, Your Honor?
Yes.
I beg to mention item number 17 of today's issue, Lordship.
Yes.
We have filed affidavit in opposition, Lord. That has not been tagged with the case, Lordship.
Affidavit in opposition in criminal petition.
Lordship,
What is this criminal
compromise petition, Lordship.
compromise?
Lordship.
Okay, what to do?
Should we take the
Okay, call,
case,
call.
Lord?
You do not know? Yes, call.
Me, please, Your Lordship.
Yeah.
Lordship, I beg to mention an application 439 offenses under NDPS Act for tomorrow.
Not tomorrow. How many days behind you are behind?
Since 28/3/2020. March.
Not too much. Next week, Monday.
May I please, Lord? I beg to mention for listing of a criminal petition of 2019 on 11th
What is the stage?
admission.
Service complete?
Yes.
Yes.
Okay.
May I please, Lord? I beg to mention item number 24 complete. What if city is not there? No, I am on interim.
Yes, when what about?
Not.
January.
Yes, January.
Interim is
Interview to continue. Yes.
24th of January.
here. I beg to mention for withdrawal of bail application for 1 to more. But it's the first time taking of getting in
Not next week.
March of
My lord, I pray for listing of an anticipated criminal motion matter. The allegation of 379 and the motorcycle has been recovered.
Now the thieves are also coming for anticipatory.
No, it has not been recovered from the petitioner.
And where apprehend? Why do you apprehend?
Because they notice is starting for
Do you have a history of
No.
doing? Huh?
tomorrow, my lord.
Monday.
Apply.
Yes.
beg to mention for this criminal.
Hmm.
If possible, next.
Service is complete.
From the time from the response.
You have put a response. Fifth.
I beg to mention for the number for what?
When arrested? City.
Yes.
What about
On 12, 12. 11, 12.
11, 12. Yes.
Only 8, 11, 22 days.
Who are you? Use the microphone.
Already, honor of the list of
Owner of the vehicle and cattle owner also already released on bail. Now he is the driver, Mother, as per his.
Okay. To the satisfaction of?
Yep.
CGM Kamuru. Nature of allegation. and period of detention. Yes. When? What about NDPS? 18.
Much obliged. Much obliged.
Yes, Talukdar.
At around 1411. And he's not taking money for as a price. The only he's the chairman of the district minority development.
This is B or AB? Huh?
BA. Arrest around 1411.
Kotakur, only difficulty is that
Nothing was recovered from me.
Otherwise, my lord, he has collected an amount of rupees 1 crore.
No evidence,
On the
only
pretext of my
only
lord
they have
1 crore, but who has lost this? And the person who is also both are members of same political party.
same political party.
Same political. The others is of the same political party, and that too of a ruling.
Ruling.
And one says that
BJP.
he is my party man. He demanded I paid him.
Paid him. And he is inquired for a minister, they have not got the money.
See the situation.
Yes.
This person, why have not arrested this person?
Yes, otherwise, my lord.
And what is the date?
Well, anyway, any short
Nothing is
statement
there.
will fix, my lord.
420 and 406.
How can you have the case diary
It's from Lakhimpur.
Lakhimpur, my lord.
at the earliest?
Yes, my lord. On
1411. Yes,
yes,
what?
1411.
No, not 14. 1411 arrested.
Arrested on
Yes,
1411.
Or
then
to have come a little bit later, we would have allowed you.
11, 12.
11, 12?
11.
11. City. Serious allegation.
Seriously,
Why?
one minor victim.
Minor killed.
Died.
There was relation, Lordship. He was
Maybe relation. For assuming for a moment that relation is there, minor is also having a consent, but ultimately girl is killed and there is allegation
Yes,
of rape.
yes.
We'll have to see the case. Yes, ma'am.
1912.
19. Yes.
My lord, already 1 month behind the bar. Allegation under section 507, 509, 501 IPC, along with my lord 67 of ITA.
The forwarding report is at page 16 from 3 to 6 months.
Yes, sir. So already, my lord, 1 month behind the bar.
City.
I prefer short date, my lord. Plus,
Then 12 months.
Lovely.
City. Kothapur.
4 months I am in custody. One important factor is this.
4 months you are in custody, search sheet file.
That's it, not yet. So far, my daughter is not yet fine.
If not yet filed, we will call for the case diary.
My first prayer is this. Why deliver a child on 15th?
No, just tell me before what is happening to you. We are having sympathy for the time being. But you tell us, can we grant you bail today in an NDPS case without hearing the public prosecutor? And hearing a public prosecutor will mean having his record. So therefore, I have asked whether search sheet is fine.
Tentative date is 15th. So any day before 15th.
Tentative date of 15 is what? For?
Tentative for delivery of my wife. So before any date.
13-12.
13-12.
Okay.
My lord, yesterday, my lord, your lordship asked me to produce the case diary, my lord. Now I have received the report from the my lord IO.
What is the report? Tell us.
Already, my lord, case diary is in session court, my lord.
Yes, Munir.
Oh, Lordship, maybe whatever one anticipative was preferred, Lordship. Maybe. I'm not
You have the instruction because you are making a statement that no bail application is
No,
pending.
439 Lordship, we had Lordship. No application pending. Because Lordship, it was arrested on Lordship 1811 Lordship. We have filed it on No bail petition. is
When
due.
have you preferred anticipatory bail application?
I'm not sure, Lordship. Maybe, Lordship. I'm not.
So you are the only accused in this case.
Yes,
So, Lord,
only
So
accused.
there must be some application where
Yes.
in which connection this
I'll
is.
confirm it, Lordship, after some time.
You confirm it and come back.
Lord.
Item number?
My lord, in this case, report,
Instruction.
yes, not yet received, my lord.
Not yet.
At 2, my lord, I will try to get the instruction.
At 2
At 2, my lord. It's on Monday, my lord.
Monday. Mr. Botakar submits that he's yet to receive instruction in terms of order dated 16/11/2023 and prays that he will be able to obtain such instruction by Monday.
Yes.
That is suspension. Accordingly, please this matter conference.
Court had said that they- sorry, they- okay.
Now you want anticipatory bail. What? City.
On 21st of December.
So the 438 application. Based on section 406 and 420.
What is your age?
Lordship,
What is the age? What is your age? Age of the accused.
23 years. My father has already told that the responsibility and already 60,000
That
has been
is
paid.
that is fine. But this time your father has shoulder responsibility. Next time,
This type of
this is the admitted position. Then you will be assured, okay, do these things. My father will come and at 60 years of age, he will return the money
no, Lordship.
and there will be a compromise. Court will say, okay, let him go. We will do it again.
No, Lord. No, Lord.
What no?
I have already got the lesson. I will get 60,000 has been paid and there is
Who paid?
my father. My father.
Your father is the main accused. CD interim appear before the IO. We'll see it. What is your conduct?
Of like 12th of January.
It, 438 BDP.
CD interim. 10 days.
Hello. Date 9th January.
$14 years of marriage.
Well, my wife, sister was murdered by them. That is affair lost by me. And then my second affair, that is annexed 2, that I have taken him, asked him for money to bribe the police so to save him from the case. But there is a decadent relation between him and our.
Which one is the affair where you are seeking bail?
Where I am praying for bail is annexed 2, my lord.
Page?
Page 17, my
Page 15 is the vernacular.
15 is the vernacular.
Huh?
Vernacular.
Which one? Where is the vernacular? Page 21 or page 15?
Page 21 is the vernacular. Our his affair, my lord, against me. Our affair is against him in annexure 1 for murdering my sister by poisoning. That is earlier affair.
CD.
Give me some protection. Well, because of this murder.
We are against these people. That may be my problem.
Well, how can it be? Because he is my enemy. He is my brother-in-law. He has killed my wife, my sister. Annexure 1, kindly see. My lord, page 12, my lord.
Yes.
12, my lord. Meher Ali, accused number 2, who has lost the affair against me now.
Meher Ali.
Meher Ali. 1250 PS case number 27 of 2023. We have no relation to each other, madam. File this case that I have.
So your sister died on 31/3.
Yes.
You lost the affair when?
I lost the affair, my lord, on 15/4/20.
15/4/23.
Yes.
And marriage was of 14
Yes,
14 years back.
Yes.
And then
This affair is, my lord, very recently, my lord,
2510.
2510.
so 3rd March she died. After 15 days you lost an affair.
Affair.
Now this is the affair.
Now he himself is absconding, madam.
Yes, interim.
Apply. Within 10 days, I will
Within 10. City interim.
Like it.
Wait, wait.
City interim.
Okay.
10 days.
Second.
City interim.
Apply.
10 days.
Second.
Yes, diary. City. When?
Apply. 24th of my lord, 13th of December.
13th of
Yeah, I prefer 30th. A lot of
You-
cases.
you make a prayer before him when he can bring it.
Maybe 11.
11.
Apply. Please, your lordship. 30th.
City interim.
Yep.
Within 10 days.
Date, 24th.
There's some other motion. For there. Supply motion. 42, 43. 41 is there. That is gone. 42.
And 43, my lord. In fact, only the in income tax act, one SSC year is found with 12 months income should be counted. Otherwise, my lord, nothing found.
Okay. We will pass our own order. Since you have not got anything, we'll allow this to be filled.
Apply.
Okay. We'll pass the common order, you will get it.
Okay.
Allowed.
My lord, here must
Yes. Let them be interim. City interim. 10 days.
highly
24th.
What is this case? Huh? City interim.
Lot.
10 days.
Lot.
Nothing is disclosed in the affair. What is,
Nowadays,
Huh?
kind of affair has been
I do not know what is this kind of.
24th.
I thought that there is mistake in the translation. Then I looked into the vernacular.
Same.
Even Assamese language is not complete. Yes.
Sorry, Lordship, that has not been withdrawn, Lordship. I have categorically mentioned in page 11, Lordship.
My lord, in this case, I would also like to point out, my lord, here regarding one AP number 396/23, for that, my lord, that case diary was sent to the, my lord,
That I have categorically stated, Lordship. That my point. Page 11, Lordship, paragraph 13.
But I am trying to get the instruction from the IO that regarding the. So probably there are many cases pending against the present accused person.
Only left us on our part, hurriedly it was filed, Lordship. We did not withdraw it because it automatically became impact to us. So,
But that's to correct this hurriedness, we do not like it.
Lordship, in the meantime, we withdraw it because it already become impact to us.
No, that is not the issue, Mr. Munir. Issue is your client must properly instruct you.
So we have already, Lordship, categorically stated, Lordship, we have filed a 438, Lordship. That the paragraph 13, the petitioner stated in meantime on 16/11, so then the petitioner preferred one application under 438 of TRPC before the learned session court against San Mari PS, this is present case, Lordship. So and so, and being aware of filing such application, the informant instructed the individual to arrest the investigator on 17/11/2020 at 10:30 p.m. arrested the petitioner. And thereafter, on the very next day, 18 he was forwarded to the learned.
Yes.
That has been mentioned. Sometimes the court asked that it should be withdrawn in the date fixed. That is it.
Okay, if you want to arrest him to the satisfaction of
CGM Kamrup. CGM Kamrup. Much obliged, your Lord. Much obliged. I'm sorry, Lord. Much obliged.
Yes.
439 application, Lordship. He was arrested on 7/5/2022. FIR, your Lordship will find page 12. There, charge sheet is submitted. 4 witnesses are examined. Till filing of the
Where is the scan copy?
Can go please. I get it that, Lordship, it was recovered from the house of the co-accused, and I was brought to the place subsequently by police. And that statement, your Lordship will also find the evidence of witnesses who were examined. They also stated that.
What is your name?
My name is Lordship Sajahan.
Your name is?
Sajahan.
How many witnesses examined?
As
4,
per
my
my
lord, till now 4. And perhaps 3rd November, the case was 6. On that day, whether any accused witness is examined or not, that is not
not exact.
How Shahjahan was brought in?
From his house, he was,
No. Why?
that statement is
In
not.
other villages are not brought in. Why he was brought
In the FIR, it is written. No? He was also present at the time of rape
FIR
at
is
the house of that Qatar.
you
At the
notice
house
the
of the
FIR, they
person.
wanted to say that I was there in the
And
place
on the
of
spot,
occurrence.
Lordship may kindly come to page 14 of the petition.
Just a minute.
That is the part of FIR. No?
You are Abdullah. I forget his name. Shahjahan.
Shahjahan.
That is also the articles were recovered from the house of it, it,
What is your ground?
my ground is that police came to my house, they searched my house, they found nothing, and subsequently they have taken me to the place of occurrence that they thought that I have been shot dead. I am nowhere connected with that. In paragraph 6, I have stated that.
Just a minute. Yes, that's what you said.
My Lord, my country, perhaps the Lordship has gone through the FIR.
FIR.
Now, in the FIR itself, it is stated that he was present. It is not. It is that is his plea that he was brought from his house to that accused person is found. No, in the FIR itself, it has been stated that he was present. And my lord, he was also interrogated on the spot, page 14, my lord. Page 14, and
He made a confession.
confession.
He made a confession.
Now, my lord, 262 grams heroin. And my lord, 4
Now,
witnesses.
how will you answer these three parts?
My lord.
First is that your story in the affair is that he was also found in the place of offense. Okay? And he made a confessional statement. These two are in your favor. And it is your case that you have recovered it in presence of independent witnesses. Now, the independent witnesses say that they were present. One is a responsible person, his wife is a member, ward member, something. So he has a relation with police. So he went there, and when he went there, he already saw these two witnesses. That these two persons, Fatah and Salek, they were tied in the campus of Fatah. And those drugs were recovered in, as you have depicted in the affair, from the house of Fatah. Fatah and Salek are the same resident. They are having the same resident of that house where it has been recovered. Now, both the witnesses say that subsequently this man was brought from his house. This is your witness, prosecution. They were subsequently brought from the different place. His house is 1 kilometer away. Now, as per his confessional statement, he is the local peddler. Only that is in 161. And if we totally believe in your story, there is no, forget about cross-examination, everything. And in cross-examination also, your witnesses reaffirm that these persons are brought subsequently. Now, in that view of the matter and the settled proposition that in case of a bail, even that confessional statement cannot be considered. Because in view of two punches, just give me the answer. So that being the position, now on what basis he will convict this man? Because his whole involvement is the recovery. According to you, he was also found. Even if we go by your statement, then it was not even stated in your case diary that you got 3 of this person in the from this position. Your whole thing is that it was inside the house of Fatah. Then you recovered it from a box. And you found this man in the place, and he also confessed. So only thing is his confessional disclosure statement, and no other witness. So far, recovery the foundation for the foundational fact that he was also present in the place. Forget about conscious possession. We'll come that later on. That his presence in the place of occurrence is negated by your.
For answer immediately, for answering your lordship's question, only relevant evidence is PW4, I think, informant. Only he has been examined.
No. Not he has been. Others will taken. Yes.
Last product thing is the PW4, I think.
No. It is. PW1 is Moinul Haq.
Yes. They are independent Caesar witness.
Independent Caesar says accused Abdul Fatah and Abdul Salik are brothers and they live in the same house. Shahjahanuddin reside in a different house. I do not know where he is related, whether he is related. I went to the common house of Abdul Fatah and Abdul Salik. I found that they were sitting on their courtyard with their hands tied with a piece of cloth. Police later brought accused Shahjahanuddin from his house and similarly kept him in the courtyard of accused Abdul Fatah. Now this is your chief. Now come to the cross. The house of accused Shahjahan is located to the northeast side of their house by a distance of 1 kilometer. The house of Bahalistan is located east of Trenchostan. So this is your independent witness. According to him, he was brought later. And recovery is from the house of this. Police wrote something on paper. Will not go to all this. See your witness. Police wrote something on the papers that place of took my signature on those papers, saying that my signature was so taken as an evidence that I witnessed recovery of drugs from cowshed of accused Abdul Fattah. As I was suffering from fever, I came back home soon after putting the signature. So when this witness was present in time of recovery, this man was not even present.
No, that is why what I submit. Your Lordship has come across hundreds of cases like this. Always independent seizure witnesses give statement like hostile witness.
But this is not declared hostile.
No, not declared. Like this is the reason why in most of the cases, most of the cases are resulted in
who was this? The second is PW2.
Now
what he says, while I was putting my signature, means in the seizure list, Shahjahan Uddiaz was also brought in. Just query to we know that it is a menace to the society, drug, that everything is argotic, the object of law is there. But in absence of an efficient authority, investigating authority, only by keeping this person inside jail, nobody can achieve the object of the NDPS.
No,
as simple as that.
My humble request, your may kindly see the cross-examination of PW4. He is the informant, whether this contradiction has been put to him or not during the cross-examination. I could not go through minute details of the evidence of PW4. PW4, he is the informant.
See your SIF. You see your SIF. So one thing is, suppose we accept this in toto. The established fact is that drug is recovered from the cowshed of Abdul Fattah. Okay. Now see your statement. You have the information that it is in the Abdul Fattah's place. We also took with us two independent witnesses, namely Moinul Haq and Kabiruddin. So these are two witnesses we have already read. Explaining them, we intend to search the house of Abdul Fattah. We arrived at the Abdul Fattah's house at South Kewti and heard gossiping. There were three persons, namely Abdul Fattah, Abdul Salik, and Shahjahan Uddin. Abdul Fattah and Abdul Salik Shahjahan, Abdul Fattah's name is revealed by our own source, and remaining two told us their name during spot interview. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. T. Das, learned petitioner public prosecutor, representing the state of Assam. The present application is filed by one filed with a petitioner who has been in custody in connection with Patharkandi PS case number 130 of 2022, registered under section 21 within bracket C /25/29 of NDPS Act 1985. Full stop. The petitioner. Subsequently, after completion of the investigation, the investigating authority filed charge sheet against airing the present petitioner as accused. Full stop. At present, the trial is going on in special NDPS case number 74 of 2022. And in the meantime, how many witnesses? Four witnesses has already been examined.
Out of
Out of
10.
Out of 10. Till now, the prosecution has examined the two independent witnesses or two independent seizure witnesses and the informant, and who is the other?
One driver.
One driver of
Police.
one driver of the police. Full
My lord,
stop.
may I make a
Yes.
small prayer? On that merit, my lord, your lordship may not make any.
That is the law.
My lord, if
If we will have to
there are
give-
six witnesses to be examined till now,
6 witnesses
that
to
may
be examined till now.
affect, my lord, our trial, my lord.
Huh?
That may adversely affect our trial of the case, my lord. That observation may not be.
No, we'll have to make it in terms of the mandate of section 37. We'll have to have a satisfaction. We'll have to express our satisfaction. Otherwise, every day they will come and say that give me bail. I am 1 year. I am 2 year. I am 3 year. This is a double-edged sword. Against them also, against you also. No way out. We'll make it. We can make an observation and discharge only for the purpose of this bail application, not for on the merit, and with certain conditions. People. One driver of the police. Full stop. From the FIR, where is the FIR, Mr. Das?
Page 12.
Yes, sir. From the FIR, it is seen that page 12, it is the case of the prosecution that on receiving certain information, they searched the house of one Abdul Fatah, F-A-T-A-H, and recovered and seized the contraband. Recovered and seized the contraband. Full stop. It is their further case that the house belongs to Abdul Fatah and another accused, namely Abdul Saleh, who are brothers. Full stop. Who are brothers. It is their further case in the affair that the present petitioner, namely Shahjahan Uddin, was also present at the place of occurrence. And he is also involved in dealing and transporting with ban contraband. Accordingly, these 3 persons were arrested from the alleged place of seizure of contraband, that is, from the premises of Abdul Fatah and Abdul. Full stop. The independent seizure witnesses in their examination on chief and cross-examination has affirmed that they were brought as independent witnesses and they witnessed the recovery of the with the contraband from the house of the joint house of Abdul Fatah and Abdul Saleh and Abdul Saleh, Abdul Fatah and Abdul Saleh. However, they have deposed that the present petitioner, namely Shahjahan Uddin, was brought subsequently to the place of occurrence by the investigating authority, whose house is 1 kilometer away from the place of occurrence. place of occurrence. The informant police officer in his deposition stated that they had information regarding the ban contraband so far relating to Abdul Fattah. However, when they reached this place, on the basis of spot interrogation, they could on the basis of spot interrogation of the other two accused person, they could learn that these two persons, including the present petitioner, are also involved in the trade. Thus, from the aforesaid, it is seen that involvement of the petitioner is on the basis of the disclosure statement made by the co-accused as well as the present petitioner. From the evidence, it is also seen that the contraband were recovered from the house of allegedly recovered from the house of Abdul Fattah and Abdul Saleh, and that the present petitioner, namely Shahjahanuddin, was brought to the place subsequent to the recovery. In that view of the matter, this court is of the view that a doubt so far recovery from the present petitioner is created, and foundational fact of conscious possession relating to the present petitioner is not there. Considering the above, court is of the view that further custodial interrogation of the petitioner may not be necessary in terms of section 37 of the NDPS Act. Now, coming to the next question, whether there is any likelihood of the petitioner involving in the similar offences in the future, this court is of the view that such anxiety of the prosecution can be addressed if the stringent condition is imposed on releasing bail. Accordingly, 1 lakh on all the dates appear, and every 15 days will appear before the IO, even if trial has started.
Observation will 1 lakh.
Yes. While parting with the record, it is made clear that the aforesaid observation made by this court is a tentative view, and only for considering the present bail application, and should not be treated as any comment on the merit of the case either of the prosecution or of the defense. Full stop.
Instead of IO, the officer instead of the because
IO may be changed. Okay, officer in charge of the police station, Patharkandi police station. Officer in charge of. Okay. We'll fine tune this order, but this is we'll do it. I will get it by Saturday or Monday. Yes. Trial is
Trial for evidence of
okay. The as office note dated 28/11/2023 reflects that scanned copies of the record as well as case diary call for has not been received yet. Registry to issue reminder and list this matter on.
One kindly see matter, page 21.
So please tell me before that. Please be kind to this court also, that I can allow you to go on bail without perusal of the record in an NDPS case, in a commercial quantity. Tell me.
No, it is 20 minutes, 30 submitted.
Submitted. BA.
Case number 18/23 dated 29/10/20.
Yes. Yes.
I mean,
Hmm.
FSL was called for. Means,
FSL report not yet received, otherwise her statement is available in the case.
Do you think that
So,
any
allegation
custodial
is regarding forgery of the signature of the informant.
forgery of
At the time of filing my lord unleave application.
who forged whose signature?
the page 24, ma'am. The SOT of the department, ma'am, that is that was page 24.
These are, I think it is preceded by some transfer, dispute in transfer, which transfer from where? Isn't it? What to do? Let them
Already-
serve the people. Interim, cooperated, material collected so far. No further custodial. Interim order needed. Yes, 22.
Yes, please, sir. My lord, this matter has been fixed for submission of injury report of victim Bakesha. It is a case of 2021, my lord, that has been occurrence to place 13/3/2021. Whole pending case, my lord. It said
Yes,
the investigating
My
agency
lord,
we'll close it. You will go there,
Yes.
surrender it before the police,
yes, ma'am.
and they will complete the
Yes.
investigation.
Yes,
Both
ma'am. Otherwise,
father
my
and
lord,
son.
For you, this has not been completed. As simple as that.
well, a statement of medical officer is available, my lord. and-
That by short.
Yes, yes, my lord. That bullet, one bullet injury, my lord, that bullet was recovered
Hmm.
from his body. That regarding that, my lord, statement of the medical officer is available, and expert opinion regarding those pistols were also available, my lord. But injury report is not. Anyway, my lord, otherwise, from the materials available on record, my lord, injury report is not at all necessary, and my lord, while the statement of the medical officer, three medical officers is also
You
available.
can, you are
Lord, there's a report with regard to the pistol, my lord.
Hmm.
Not injury, man. I am on injury report. Rakesh Ali is first admitted in the Hazu hospital, thereafter sent to the medical college hospital. And what injuries sustained? He is
gun injury, sir, gunshot.
human. Yes, my lord.
My statement of three
That
doctors available.
injury report, my lord.
That
That is
doctor's
different thing.
statement.
lord.
This is not a case, Mr. Ahmed.
Your lordship. Such a long period since 2021.
Oh, then it will be every criminals
Till
like
date-
you will kill people and roam around. And after 2 years will come. What is the investigation is complete? Let me be in.
Lordship, absolutely correct. But method
That cannot be the ground that it's all pending. Then dreaded criminal will be granted for bail.
I am submitting like this, my lord, that till date the injury report has not yet been submitted by the investigators without sufficient reasons, man.
Bakesh Ali's
Yes, ma'am.
bullet from his body
Body.
was recovered in a
But this-
operation in emergency that is available on record, and CCTV footage shows you are the person.
Yes.
Do you want to record all this in a bail order?
My lord, absolutely correct. But thing is that
Hmm.
the injury report
If
will
I
not
am
be stopped.
correct, I am dismissed.
There is no such incident happened. Nobody was injured.
Nobody was insured.
That is why
All
injury
this-
report failed to submit.
That we have seen the statement of the doctor. It was in the emergency, so and so patient was admitted under so and so. He is the person. Do you need now now he'll say that we need the gun, the bullet rejected. Yes, that is returned back. Sufficient incriminating materials are available against the petitioner in the case diary as well as the petitioner, and sufficient material suggesting that the petitioner is absconding and avoiding. Next.
23, my lord, charge sheet submitted.
Charge sheet submitted being charge sheet number
Charge sheet number 398/23, dated 31/10/23.
dated 31/3/20. Interim is there, huh? Interim is
Here the case of tax date is 7/12.
that will not say anything. Interim order dated
Interim order dated
29.
8/9/2023.
8/9/20.
8/9.
Dispose
Deeply obliged.
dispose of. Yes, whatever I think charge sheet is filed.
25, my lord.
Yes, here was the interim. CD is there.
I can know 25.
CD is there. Who is the FI? Who are you?
Owner of the day.
You have appeared.
Appeared.
Okay. Dispose. Same terms and made as well. Yes, what is this?
Case diary was what?
26, case diary not received. It was some implement of the informant
Interim.
yes,
When?
on the 9th of January.
9th of January. Interim. Yes. Yes, any interim?
Interim here appeared.
Appeared. Dispose. Yes.
430 deputy. Where is page number 11? Start from 11.
POCSO or what?
But here charge sheet.
Charge sheet submitted. No interim.
So interim.
Charge sheet submitted.
Charge sheet number.
Charge sheet number. What protected? You go apprise the court if material is so the law that your
Yes. The admitted there been a statement together. Correct. Yep.
show this in the trial court. So the law that once there is any law is not necessary at the stage of trial. If not necessary, then court that no bail is granted. For that reason only, they should not be put behind bars. It has been so before we state that law. That application of mine is to be from the materials collected, isn't it? Nothing is before us, isn't it?
Diploma.
Yes.
439 application file merit alert. FIR page 7 in one third person we have filed the FIR.
It is there.
It is there, but it's father. Oh, the girl, her 164 is not here.
No marriage.
Her 160.
Without marriage, you are keeping her what?
No.
Now I'll take that course or what? That is a will be very dangerous.
Her
That will come and say that not married.
164 statement is not here. But 161, she said that she loved that person and they are staying together, but no marriage.
See, it's a new trick now. If not married, not married. There is a bar. Anyway, have you appeared?
No, I think
No intent.
service.
Okay. Case diary is returned back. Interim क्या? Oh, don't tell me about service and statement on affidavit by a minor victim. Do you want me to pass an order? The value of this affidavit? You want to pass me an order? What is the value of this statement, affidavit of this girl? Granting absolute, he will appear with a condition, 10 days. I am. Yes, Madam Chaudhary, what is this?
Petitioner is holding a responsible post. He is the principal of the
CD not recipient.
It is not received.
After the order dated 14/11,
Hmm.
he has tried to serve custody on responsible by the nephew of the petitioner had in fact gone to serve the same. Thereafter, we had filed the nephew.
It is not here. Let the CDP here, we'll see what is statement. It is a 13-year-old girl. He has committed a mistake, no doubt that it.
Yes.
That he has allowed a person to go for study without having any leave.
Fine.
You are the in charge of those things, and you put him under pressure. That why have you done it? To that extent, this is fine. That you can say that you have done an illegal act against him. But if you put a pressure to might be a renowned teacher that give me money, or through otherwise through all this Facebook journalists that all having own channels, will through them you will extract money. That
even in that
pressure,
even in that event, my
we'll
lord,
see
with
therefore.
folded hands, my lord, with folded as a student of law, my lord. First of all, there
We
are
understand that will be
107 IPC.
that can be a question of framing of charge. That can be a question of something.
Lots of
But at the stage of bail, we may not go into so deeper. So deep.
Lots of it examine.
We'll examine.
Highly obliged.
Yes, case diary produced is not up to date. Accordingly, the learned counsel for the learned additional public prosecutor praise foreign is granted 10 days, 20 days. Granted time till 19th of December 2023. Why make it 19? Make it January.
I'll have to run away from police then. I'll be here from
at least you will have to come.
Yes.
At least run away. Run for some time more. 19th. We'll see 19th of December.
Highly obliged.
Yes.
Obliged.
Why this matter was mentioned, I forgot. It is with somebody, something else. It is to be taken up together with some other case. That series matter. Along with you see this series of 3487/2023. I mean, along with
Around item number 56 of
okay. Order.
Talking about task procedure, the update health report of use was thought for honorable in the eye. Please put the eye along with the Lordship on task occasion, Lordship was gracious enough to point out that in this matter, the assumption since it has taken to the line of argument has to go. in connection with the Lordship Council has shared and has come up with a few citations. I can.
What is this? What is that?
The accused has been convicted for committing an offense under Section 4 of the POCSO Act, and he's behind bars in 1 year, 2 months. So he's a patient who was suffering from hepatitis, and for that reason, around the medical ground, the IA was sought for, along with some other grounds were also there, regarding the fact that witnesses which were being examined by the prosecution tends to be of interest in nature, and most of them were family members. The only main contention that lies in this particular matter was that presumption was taken since the victim was found to be child, as per the definition of POCSO. And
What is your age?
14 years, as per
No, age of the not victim, age of the
accused.
accused.
I
Whether notice, sir.
I'm 29 years, 29, 30 years. If I not allowed, yeah.
Whether notice is served.
I thought it is something that was not served. The respondent
What is about the service?
notice was not served. The informant.
Then that will be required, no?
Yes. It- uh,
When have you taken step?
I thought it has come to my
2022. Supplementary file. Okay. In view of Peru's the office note dated 28/11/2023 and also the service report. The notice has duly been served. The notice has duly been served upon the respondent number 2. Upon the respondent number 2 on 16/12/2020. Okay. Service is complete. Then paper book is ready. Some other day. Today may not be possible.
thought it
Give a date. No,
for the I.
Service is complete.
But
Paper book has to be prepared.
6 December.
However, Mr. Learned Counsel for the petitioner praised that the IA may be considered. In the IA, affidavit has also been filed by the public prosecutor. Accordingly, please this matter on 6th of November 20, December 2023 for consideration of the IA.
apply.
Yes, Mr. Sigdar.
I may have it that this was taken by insert as well as dual. in respect of one, he refused to accept the notice of court actually detail. Nothing has been
Okay. In view of office note dated 28/11/2023, matter be placed after in the month first week of January with an up-to-date service report. Full stop. Interim order passed earlier shall continue till then. Right. Yes, yes. Objection.
officer did not file ballot. Last time also they did not file.
When?
Lordship, 2 weeks,
3 weeks will be.
3 weeks,
2 weeks. 2 weeks.
3 weeks, sir.
There are serious contradictions among the star witness. Cases of acquittal. So that
After 3 weeks.
Not 3 weeks. 2 weeks. 2 weeks.
2 weeks.
Uh,
My lord, second time, my lord, but
Huh.
it's ready, my lord. I can file tomorrow also.
okay. Okay. So, the learned Mr. Goswami learned additional.
37 or 36? 36.
Mr. Goswami learned additional public prosecutor submits that he will be able to file the objection in the IA by the next
Right.
Monday.
Yes.
Next Monday. Accordingly, matters stand adjourned and be listed on give a date 18th. 18th of December. No, next week. 13th of.
I'm open.
और कितना साही पहला डेली है okay NCB keep it separate which are the NCB cases and any other NCB cases just separate these NCB cases 53 59 okay and in your case
My case is 46,
46 47 just separate this 48 just give a list separate it we are coming see one thing is there we are sitting till 1 then only for half an hour so to the extent possible we'll continue and those which will remain will see no give us that NCB no give a list who are in NCB give a list so that he can separate and call the matters other matters he will call the relating to Mr. Bortha. $49
Lordship, on only basis of the bank of 477 days. That rate Lordship they have asked slide out.
okay charge sheet is filed
Charge sheet file Lordship. 9 PWs are there Lordship. The charge sheet was filed on 30/11/2020.
scan copies here these are not material or scan copies tell us the three four things here arrested on
Lordship, arrested on Lordship 9/8/2022.
9/8/2022
Lordship, as on date 477.
okay And charge sheet filed on
Charge sheet filed on 30/11/2020.
30/11/2022. 2022.
9 PWs are there.
Then any charge when?
That has been framed.
When?
Or to that date, I don't have exact lordship.
PW also might have.
Examine lot. PWs are examine.
They're not that. We want to see at what stage the delay is. Suppose from 9/8 to 11/8, they have filed their charge sheet almost promptly. Now it comes to 30/11. Where is the delay? And what is the reason? You are Rabial
Rabiul Ali, my lord, two are there.
and Sahar Ali.
Sahar Ali. 2%.
Hundred 50 bottles.
Lordship.
Each bottle of 100 ml.
You are driver.
Hello.
Driver and handyman. And truck belongs to whom? He is not an actor.
No.
When the first PW started?
Page, my lord, in the petition also page 26.
No,
And
tell me the date.
Date lordship is not mentioned in the signature part
It will
of
be there.
This is important.
Yes, my lord.
That is what we told you that you go through it. These
Uh,
are the vital questions.
I have flag marked my lord PW1.
PW1 to you have marked, but
Yes.
we want when it started. Mr. Munir,
I'm sorry.
don't be half-hearted, and don't put everything to the judge. This is your case. You are everybody is arguing questions of Article 21.
I'm sorry.
So you are also to the part of protecting the right of a person under Article 21. His whole case is Article 21. And if you cannot say that when this evidence started, how much time they have taken, on how many occasions they have failed to produce their witnesses, on what ground will you grant you bail, ignoring the provision of 37?
A mistake lordship, I didn't go to the SPR.
That is not say the mistake. That is a major mistake. Problem is that we cannot look at the face of the lawyer. We look at the pity of accused. If possible, we'll give. But problem is that if lawyer's assistance is not required, I'll go through, I'll see everything, every page. You do not know the date of framing of charge. It's not the way to do a case. That
after
to a
some time, Lordship,
council.
after some time, Lordship, I'll go to the
Is that a high tail on 6/1/2023? The charges were framed.
it was on 30/11.
30/11. So it took almost so many months. For what reason, we do not know. We'll have to see each and every page. Now, from 6/1, first witnesses were examined when? And what are the reasons? Can we say because it is 1 year or 2 year, you are entitled for bail? As the learned counsel for the petitioner is not ready, list this matter on Monday. In the meantime, he may go through the scanned copy. Yes, next. PPB. Yes, Ahmed.
My name is Sonita Kosodo.
Okay.
In FIR, your lordship will find page 10 and relevant for the page 12. Here, the main reason was that they received an information regarding a vehicle and accordingly it was intercepted and contrabands were recovered from the bumper of front tire. And there were two persons, driver or the owner of the vehicle, and I was there.
What are your grounds?
My grounds is that first thing is that I was not aware about the contraband. I was just boarded in the vehicle. And second thing is that the charges I am behind the bar for 1 year, 7 months, 4 days.
Where is the FIR?
FIR, your lordship will find page 12.
What is your name?
My name is
Tajuddin.
The Lordship and the order dated 25/7/2020. One of the person is still absconding and against him FPW is not appeared. Initially, charges were framed against person. One PW was examined. Then court realized that one person is still absconding.
Who is absconding?
His name is page 15. Lordship will find three persons are absconding. Ostu Mia, Suleiman Uddin, and Sadidi.
What is the procedure to try them separately?
It can be stated out, but my lord, that case has been now, my lord, PW1 has started, my lord. So, my lord, trial has begun. So, with respect to this petition. So, leaving aside those who are absconding, my lord, I'll learn my here what is Tajuddin. PW1.
Two things are here. You see, first is that it was recovered from an auto vehicle in a concealed state.
Yes.
inside the bumper.
Yes.
For the purpose of bail. Now, is supposed to cases were recovered from that place.
No.
These two persons were inmates
Yes.
of that vehicle.
Yes.
It is not a public vehicle, it's a private.
Private vehicle.
So regarding the possession, we'll more or less we are having subject to further evidence. We are
Yes.
having
At this
at this
private
stage, at this stage.
passenger.
Now question comes is that date of arrest is 6/20/2022.
Yes.
Okay.
Yes.
Charge sheet was filed on 31/7. Okay, fine. If that much we can give you liberty. Now charge was framed on 28/9/2022. Okay.
No.
Now 8/9/2022, the first prosecution witness was examined on 11/7.
No.
See the date from 28/9 to 11/7. Now, what is the provision? We are giving a time, framing a time period here. It will not be possible at this stage. At least something has started.
Okay.
We'll give a time frame.
Sometimes, my lord,
Time frame. What is the provision that it can be separated, split?
yes, my lord, already stated, my first has to be declared in front of the court.
Yeah.
Then, my lord, 317 will come for separating the seat. They are absconded. Right.
Now, what is the order? Last order?
Last order takes 24.
And also, my lord,
See, this is another aspect because they cannot be continued. Suppose you are not able, they will have to proceed. No?
yes, yes. Sometimes, my
Proceed.
lord, fair amount of reasonableness was there, my lord, for waiting, my lord, if my lord, NPW can be, my lord, executed. That is why 2-3 days, my lord. Sometimes it is thereafter, my lord. It was.
What is the present status, Mr. Ahmed?
Presently, NPW, they have not appeared.
Not appeared. What is the next date?
Next date is, my lord.
As per this order, it was 8/8. Definitely, it is now we are in
11.
11. Definitely one date will. Because so now we'll say that proceed in terms of section.
T1. But that arrest not yet. Then only will
Problem is this so casual. Somebody will have to intervene so casual, not only interest of the prosecution, for the defense also. Someone issued not returned, issue prisoner. Someone issued not returned, issue prisoner. It's a casual order every day is being passed.
Yeah, exactly. What should be issued? Someone should be returned.
No, someone should be returned, but
Yes.
something must be. Courts are regularly issue summon.
Yes.
Now the public prosecutor will give the details. We are not blaming anybody, but ultimately it will be submitted at such a that by the time next date is fixed, it will not even, there is no scope to get it returned. Again, you issue a fresh summon. So there must be some procedure like our. And other aspect is that most of these witnesses are your witnesses. You will have to have also an initiative. Otherwise, that is the reason why even in NDPS, people are being allowed. So lethargic everywhere.
In my lord, in a separate, it is not regarding this case. In one case, my lord, all the witnesses are, my lord, 4 to 5 witnesses are all the police witnesses. So, my lord, coordinate bench, my lord, there is passed an order to the, my lord, assistant judge, my lord, taken, my lord, report why they are not appearing. And it was, a copy was sent to the DIG office, my lord, and thereafter, everything, everyone came back.
So see,
That is
you are, as Mr. Kyle has yesterday said, there is an object of this act. So who is the authority for which these objects are not being achieved? And courts are compelled to pass orders releasing them. You will have to balance. It's not that a person will be inside and continue to be inside, and witnesses will not come for that reason.
No.
That cannot. We will have to balance. We will have to see the menace of these drugs, and at the same time the personal liberty
No.
and the conduct of the prosecution.
Now, my lord,
Now
in-
suggest us, Mr. Ahmed, what to do here. Bail is difficult. Bail is difficult. In a given case, we have allowed, but this is not a case for at this stage.
The direct, but
Will not cannot direct separate because there are some procedure. So if it is
As per
still
procedure.
absconding and after following the procedure, do the needful in terms of section. Yes, section 2020. And hereafter,
3 or 4 months.
who are the witnesses?
now, my lord,
9
9 witnesses are there.
Ensure the appearance of the witnesses, even necessary to the DGP. If
Yes.
give that order.
Yes,
If you are having that order,
not now, but I will provide it.
we will not comment anything on merit for the time being. But
in one case, our High Court rejected bail application of there was fair for bail on the ground of state, and that was rejected. But the Honorable Appellate Court granted. Only on that.
I am not at all convinced. I am convinced that you have a right, but it is to be determined. The right will is to be addressed on the facts of the given case. There cannot be any formula like this. That
Paragraph 17 of the bail order of our
go dear, we cannot pass this kind of orders.
was before passing.
So will not let us not comment on your other 37. We'll say that he has argued on only on the period of case. Do you or you want to go upstairs? If you want to go upstairs, then we'll say that this is not the case under 37. So we can give you, we'll give 6 months. Fine.
Only 9 witnesses are there, one already 4 months. They paid the
Time frame, my lord,
again coming to this.
No, like, that's such absolute casual. That cannot be. We will not permit it. Everybody.
6 months.
See, where is Mr. Kyle? They are saying that's the purpose of section 36 special courts is to be constituted. Where is the infrastructure for special court?
No.
The same session judge is entrusted with special court POCSO, special court NDPS. So whole object of 36 is defeated. Call him. He has said that object of this act is very great. What his Union of India is doing, giving finance to the state government that create this post, have the court building so that we can have special court, special charges for NDPS and POCSO. Saying is very good, but doing is difficult. Heard Mr. Ahmed, Learned Counsel for the petition. Also heard Mr. Goswami, Learned Additional Prosecutor. The present application is filed seeking bail by the petitioner, namely Swenso, who is in custody in connection with in connection with special NDPS case number 40/2022 arising out of Patharkandi PS case number 69 of 2022 registered under section 21C/29 of the Narcotic Drugs and Psychotropic Substance Act. Full stop. The petitioner was petitioner and another accused, namely, what is his name?
Yep. SAIP.
Saipul. SAI.
SAI.
Saipul.
Type Putti.
Saip. SAI. SAIP. UDDIN. Saipuddin. On the allegation that both of them were arrested while possessing possessing contraband kept in a concealed state in their vehicle in 27 soft boxes. Full stop. After completion of the investigation on 6/3/2023, 6/3/2022, after completion of the investigation, the search sheet was filed by the investigating authority on 31/7/2022, and thereafter charges under section 21 within bracket C slash just tell us the
21.
21C were framed by the learned trial court below on 28/9/2022. The prosecution has prosecution is relying on 9 witnesses as cited in the search sheet. Full stop. The first prosecution witness was examined on 11/7/2023. That is almost a year from the date of framing of searches. Inasmuch as the first prosecution witness is the informant himself. Is that it?
No, my lord.
First is a Caesar witness. Full stop. Who are the witness? These witnesses?
Page 17, your lordship will find.
Page
7.
17.
Second paragraph. Serial number 1 to 9.
The all the witnesses cited except the except
2, 3, 4, and 5.
no all are police officials.
No, man.
Huh?
2, 3, 4, 5 are, my lord, independent witness.
Except the witnesses number 2, 3, 4, and 5
Stated in the search.
cited in the search sheets. All other witnesses are officials either of the police department or of the expert, FS expert, or of the expert.
Yes.
Full stop. Full stop. And therefore, in the considered opinion of this court is that there is a delay in examination of the witnesses by the prosecution, inasmuch as search sheet was filed on 28/9/2022 and the prosecution witness was examined on 11/7/2023. It is also seen from the record that after examination of PW1, the learned trial court could realize that charges has not yet been framed against other co-accused persons who are still absconding. And therefore, the trial has already been, trial is to be postponed, and it is also seen from the record that warrant NBWA has been issued against the petitioner on against the absconding accused on 25/7/2023, and the matter was fixed on 18/8, something like 8/8/2023. Full stop. Thereafter, the matter was fixed on
thereafter now it's fixed on 4/12.
thereafter also 2-3 dates as stated by the learned counsel has passed in the case, and the next date of the matter is fixed on 4/12/2023 for report on the execution of the warrant against the absconding witnesses. Full stop. In the aforesaid backdrop, this court is of the view that the petitioner cannot be put under custody for long without awaiting the execution of warrant against the absconding witnesses. Full stop. However, considering the at the same time, this court is of the opinion that the trial should be completed within a period, within a specific period of time, looking at the mandate of the NDPS Act, in as much as the right of the petitioners to have under Article 21 of the Constitution of India. To balance the aforesaid, in the considered opinion of this court, let the learned Special Judge Special Judge NDPS Karimganj take a final call on the warrant issued against the petitioner in terms of Section 80 and proceed in terms of Section 82 of the CRPC and if necessary split the trial and if necessary thereafter split the trial and have a separate trial against the present petitioners. First of, in view of such, in the aforesaid backdrop, the present application is closed with time frame to the learned special court below to complete the trial within a period of 6 months from today. Huh? Huh? 4 months. Okay, 4 months. 4 months. 4 months from today. 6 months. 6 months. Mr. Ahmed, 6 months. 6 months. 6 months. Because we also cannot put the pressure. These officers are. They are also. You cannot blame for the delay. They are also single-handedly. Where is Mr. Kyle? I have seen him.
Every day they might not sleep.
So there is no special court. Session judges are taking NDPS. Session judges are taking POXO.
Special court is there.
Special courts by name.
Yes.
They are the session judges.
Yes.
For the sake of the authority.
In case of NDPS, special court was created due to infrastructure by the state.
That is the problem. So that you have said that the object of the act is to control this problem, who is killing the society. You have cited some judgment which says that it's larger crime than a murder.
Yes.
But if the condition of state is like this, how will you achieve this mandate of parliament?
Now, all the cases have been played about the
We understand. But is it a job of the additional citizen just to do NDPS cases?
This is the typical.
So if you, for your difficulty, why should you allow the people to be inside? See, Mr. Kyle, your most concern is that this is a situation.
Yes.
You are not creating infrastructure, judicial infrastructure. Not, I am not saying Mr. Kyle. I am saying the state.
Obviously.
Maybe Union of India, maybe state government. Union of India will have to help them. This is not a state crime. It's a, you are, according to you, this is an international. This is having an international link. Anyway, we know that any other person within a period of 6 months from today, and if such proceeding is not concluded within the appropriate period, the learned session judge shall consider the case of the petitioner for bail in terms of the law laid down in the case of Ravi Prakash versus
State of Odisha.
State of Odisha, reported in
Case number I will
in 2022 Ahmed, along with other relevant provisions of law after hearing both the sides. However, it is made clear that while if the delay is caused for the fault of the petitioner or petitioner's lawyer, that should not be treated as a delay on the part of the prosecutor.
In this particular case,
Yes.
this case has
Disposal.
this observation, this particular case only my.
Okay, the
Because-
present order is passed, should not be treated as precedent in as much as the present order is passed in the given facts of the present case. But no way out, we will have to pass this kind of order. You may not say precedent. Yes, next. Kyle, are you ready?
Yes.
Then we'll call serial here. Yes, Pannan. What to do? We are having only half an hour and half an hour.
I just it that
No, you will place your just case. I'll have to dictate each and every case, all the facts.
already that is the in basic obviously a lot of people have to pick up it.
So therefore, what will you do is we will continue after, no, if necessary tomorrow.
I have no problem.
Okay.
Since I was there, my time is there behind bar for 4.5. Another 4 days will not.
No.
In fact, I am having some
You are
difficulty
almost sure. You are almost sure that after 4 days you are free.
No, I am not sure.
Any other lighter said.
There is two things. If I am not free now, someday I will keep. That day will come. One
Nobody can keep anybody.
5 years. I am approaching 5 years.
5 years.
So that is one. I have not argued.
No, no.
Your lottery is not taking up.
No, not taking up. No, I am thinking that we will have to rise around 2:30.
Yes.
Initially, I thought that I will continue, but that may not be good for everybody taking during the lunch break. So we'll continue. Yes. Anyways, we'll try. Yes, Mr. Yes, item.
46 and 47.
47 can take up 47 plus that criminal.
It's arising out the same. One is bail, other is criminal petition. Criminal petition so far relating to the non-production
Yes.
during extended period of extension.
Production not informing, and it is covered by Jigar.
No, you know that. According to you, you were not informed.
Not in.
How do you say that? Where is the order on
Order itself-
order of extension?
Order itself says that order your lordship will find page 18.
Page
80 of criminal petition.
Page 80 of criminal petition. 18.
And considering the gravity of offense, that cannot be a ground for extending. I have heard the ladder council, ladder special subcommittee.
Mr. Kyle,
Look.
if we are technical in a law, it's so technical and hard. We are bound to be technical.
Yes, Lord. In NDPS, Lordship, this is the law.
So even there is produced from the jail to video conference. At least there should be a line that the petitioner was informed that we need that they are praying for an extension, or even a line that also heard the petitioner through video conference. Matter ends there.
Lordship, that's why record has been called for by your. That's why to examine to see whether this provision has been taken care of by the learned sessions as well, passing the order was there or not. So LCR was called for.
What do we need? Can we need to go behind the order?
No, Lordship. Before
A judicial order is passed. If the learned session is not aware of the settled proposition of law, what can we do?
in also got a lot TV faces. We are facing.
You'll have to inform the judges. Let's see, you ask a question.
Even Lordship councils are also not aware of the provision. But Lordship may please to see section 36(4).
Section NDPS.
Yes.
Also NDPS. (36).
36 4. Capital A4.
Yes.
In respect of persons accused of an offence punishable under section 19 or 24 or 27A or for offences involving commercial quantity, the reference in subsection 2 of section 167 of the CRPC thereto 90 days where they offered shall be construed as 180 days, provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year on the report of the public prosecutor, indicating the progress of the investigation and the specific reasons for detention of the accused beyond the said period of 180 days. So, Lordship, the condition precedent is that there must be a report of the investigation that should be supported by IO. And other conditions whether accused to be heard, it is not. It is by the pronouncement of the Honorable Supreme Court.
That is law.
That is
in terms of Article 141 and 142.
Not because there is a judgment of name is the area. And that Supreme Court says that it is incumbent on the authorities to inform the accused and notice is to be served and he is to be. That was the by judicial, but section itself doesn't only two conditions precedent were there. So law is on that notice should be put to the accused. He must know that application has been filed for extension of time. If he has anything, he can submit to court. That is the law as on date. But section doesn't say.
No, we are not on that. The law as explained by the Honorable Apex Court as on date.
Yes.
That is why I have said that even if there would have been an order that he was intimated, then so also heard him, that would have sufficient. Here is a case, he is present by virtually so has said, so allow it. Why it is necessary? In fact, according to me, at least a reason is necessary that these are the grounds for which this extension is taught. I am happy and satisfied that this investigation is necessary. You need not give reason. Why are you satisfied? You pass an order.
That could have been required.
So we'll allow this.
I want to place two judgment.
What judgment?
No, Lordship, because in the 23, what case in case of giving default bail, 41 judgment that is. And Lordship, another in one case in Hitendra Vishnu Thakur, Supreme Court in 1990.
Hitendra Vishnu Thakur, then thereafter Sanjay Datta, everything has been discussed with the Honorable Apex Court, including.
If a charge sheet has been filed subsequently, then Lordship has to taken into consideration that charge sheet the gravity of the offense.
No, his right matured.
No, Lordship.
On the date. Then why should we look into?
No, Lordship, in one judgment, I'm just taking one paragraph. In case of West Bengal, Lordship,
If accused is present, that is sufficient, but I'm not relying on that.
Okay, fine. Accused is there, but Supreme Court says otherwise. I am even going to that at least heard the
No, that is
nothing is there. Can a judicial order sustain?
this is the problem.
So problem will have to have an
Yes.
answer. We cannot say that this is a problem. Our officers are
No,
not
no.
aware of the judgment.
No.
So okay, let him be inside because our officers are not
I'm
aware.
not committing that.
Then
Our officers are
in fact, not your officers. I am saying our officer.
yet.
Now, in fact, your officers is also have a responsibility. Please,
Even Lordship, I say
you
that
will see many lawyers who will say, no, don't pass an order of interim. Hear him.
Lordship, even Lordship, the councils are not aware of this provision.
So that cannot be against that lack of knowledge cannot be used against.
No,
an,
I'm just committing for this is the reality we are facing.
So we'll pass this order. Let us not waste time on this. We'll go for a meritorious case. I have the ready reference. Let us not waste time. Hard, Mr.
Even Lordship, if default bail is granted, that can be. It is
They can tell us.
You tell it. No problem on that. Hard, Mr. Will so bail will tell it to be an influx.
So then bail has to be granted for bail. Because I filed default bail application, then only I came to know
No.
that before the trial court I filed default bail application, only then I was informed that that is accepted.
Where is that? Pass the common order.
Yes.
Criminal petition 99910 and
PA number
2491-2023. Heard Mr. Ahmed, learned counsel for the petitioner. Also heard Mr. S.C. Kyle, learned standing counsel for NCB.
for custom.
This custom. Learned standing counsel for the customs. The present application, the criminal petition is filed under section 482 of the Code of Criminal Procedure 1973 for quashing an order dated 12/6/2023 passed by the learned special judge Karimganj in special NDPS case number 1 of 2023 arising out of departmental case number 02/CL/NDPS/AS/KXJ/2022-2023 dated 28/12/2022 registered under section 22 within bracket C/29/60 of the NDPS Act 1985, whereby the extension for filing offense report was granted to the prosecution. Full stop. The bail application is filed by the same petitioners in connection with the same case on the ground that the investigating authority has failed to file the final complaint in terms of section 36A capital 36 capital A within bracket 4 of the NDPS Act. NDPS Act inasmuch as the authority full stop. The two petitioners herein were arrested
on Lordship at 28/12/2020.
28/12/2023 2022 in connection with the aforesaid by the custom authority in connection with the aforesaid departmental case. In terms of the quantity and nature of contraband and by virtue of mandate of section 36A within bracket 4 of the NDPS Act comma, in the given facts of the case, the given facts of the case, the investigating authority was to complete the investigation within a period of 90 days. 180 days. 180 days. However, admitted such investigation was not completed within the aforesaid period, and the petitioners were in custody during the However, the custom authority, where is that order? Impugn order?
Impugn order page 18.
Page 18.
18.
In the
Criminal. And in bail application, it should be
sir, tell me the bail application.
page 23.
Page
20.
equal on 12/6/2023 made a prayer through the learned special paper, made a prayer before the learned trial court through the learned special prosecutor seeking extension of time of submission of the final complaint in connection with the NDPS case. On the basis of such submission, on the basis of such written prayer, the learned trial court below, under the order impugned in the present petition dated impugned in a revision petition by the application under its order dated 12/6/2023 impugned in the criminal petition allowed the extension of time for 1 month. The basic grievance of the petitioner is that while allowing such extension of time, the learned trial court has ignored the settled proposal. Learned trial court has not heard the petitioner or issued notice to him regarding such spectrum of seeking extension of time by the investigating authority. According to Mr. Ahmed, that being the position, the extension order itself is bad in the eye of law, and therefore the same is liable to be set aside, and the petitioner is entitled to be granted default bail in terms of section 36A within bracket 4 of the NDPS Act. Per contra, Mr. S.C. Kyle submits that though there is no reflection on the record that the petition no notice was given, however, from the order dated 12/6/2020 itself, it is clear that accused petitioner was produced from jail through video conferencing. Therefore, said petitioners were well aware of the factum of seeking extension, and the learned court has passed the order considering the necessity and the reasons as explained in the written order. Therefore, only on the technical ground that no specific notice was issued to the petitioner, the said extension order cannot be interfered with, inasmuch as in the meantime the authority has submitted their final report during the period of extended time, and there are sufficient materials in this regard. We have given anxious consideration to the arguments advanced by the learned counsel for the parties. Full stop. It is no more res integra that the right of an accused under no more res integra that that it is mandatory to produce the accused at the time when the court considers the application for extension of period of invasion, and that accused must be informed that the question of extension of the period of investigation is being considered. Inasmuch as the accused shall have a right to raise objection to any application for extension. Full stop. Such determination has been made and ratio laid down by the Honorable Apex Court in the case of Sanjay Dutt and in the case of Sanjay Dutt versus State of Maharashtra reported in
1994 5 SCC
1994 5 SCC
410. In paragraph
410.
50. And in regard alias Gibney in criminal appeal number 16.
Okay, will not, no citation will not go. Okay, okay, fine. Full stop. It is well settled that the investigating authority has been given and mandated to complete their investigation in terms of section 36A within bracket 4 to complete the investigation in within a specific time frame, with a proviso that such extension of time can be granted if the learned trial court is satisfied that extension is required. Full stop. Thus, if such investigation is not completed within the mandated period prior to extension, the petitioner or accused shall have a right for release on default bail, which is in the considered opinion of this court, is a valuable right. And therefore, to negate such valuable right, the petitioner should be put into notice that that his right is sought to be curtailed for certain reason, so that he can also make his explanation. However, explanation and according to this court, this is the procedure established, should be treated as procedure established under law to deprive a person from his valuable right guaranteed under Article 21 of the Constitution of India. In the case in hand, if we go to the order, the following facts are discernible. That accused was produced from the jail through video conference. 1. 2. A written prayer was submitted by the learned special public prosecutor showing the ground to pass necessary order for extending the time for submission of report. On the basis of aforesaid fact, the findings of the learned court is that due to the considering the gravity of the offense, the prayer of extension was allowed. However, it is not absolutely discernible and clear. It is clear from the aforesaid order that the accused was not put on notice or even was not told verbally that an extension has been extension for filing the report has been filed, and he has a right to object to such application. That being the position, in the considered opinion of this court, the due procedure established under law to take away the right of the petitioner under Article 21 of the Constitution of India arising out of the mandate of section 36A within bracket 4 of the NDPS Act is violated, and that being so, the impugned order dated 12/6/2023 is not sustainable. Accordingly, the same is set aside and passed. In view of the aforesaid findings, this court is of the further opinion that the petitioner is entitled for default bail in terms of section 36A within bracket 4 of the NDPS Act, inasmuch as admittedly the final report was not filed within the specific period of time as mandated under law and discussed here above. Accordingly, the petitioner be allowed to go on bail with the following conditions. Local security, even if during trial you will have to be present before the officer in charge. Anything is there? Court. On and it's every day. But if he is involved in, we generally give that he will go give to Hajira to local police station. Or what? Or you have any police station?
No,
NCB,
police
custom. So what, sir?
But we have no.
You will be released here and again be involved in other cases. We are giving you technicalities. Remind yourself.
Interestingly, because today
that is why, so that we want that every 15 days he should appear before the local police station. Huh? Police station is before the officer in charge Categorizing police station every 15 days. And each and every day he will appear before the trial, before the court, and shall not indulge in any of such activities under NDPS. And if such conditions are violated, the authorities may come for cancellation of it.
may add the word default.
Huh? Default. A default we have added. No, you don't want the default one.
No, we want that.
No, we have given default. Default.
Because there is a
Local.
No, special just.
Huh?
Special just.
Special just for him.
How that?
Yes, Manlan.
Yes.
What is the date of arrest? Yes, madam, give the slip.
The date of arrest, your lordship, was on
What? So yes, madam, 1 minute. What was I telling since yesterday? Give it.
date of arrest is 5/10/2009.
Alcohol. Huh? What?
The date of arrest is 5/10/2009. Case registered under section 21 and 329 of NDPS. Then 1/4/2020, the charge was submitted. No, it is actually 2/4/2020, not 1. That is wrong. Charge is submitted.
1/4.
No, it's 2. In the record, it is 2. I think that's wrong. It's 2/4. Charges frame after about 3 years. That is 31.
Why this delay?
for during COVID period, the trial was till 2020 March.
2023. 3 years.
COVID was gone.
He was arrested in 2019.
I became judge in the 2021. At that point of time, there was no COVID. I only remember that. Now we are already 2 years.
Yes, correct.
So COVID was beyond
2020, I understand.
2/4/2020. Okay, April 2020 we can understand that courts were, even April 2020 courts were functioning.
time was extended because of Supreme Court, 2020 March.
Time was Supreme Court also said that let everybody go.
No. There was a direction from the Supreme Court that those persons who are in third stage are allowed to go during the COVID.
Okay.
So that is with regard to the date. Then what has happened, your
You
lordship?
belong to which state?
This is from Tripura. Person is from
Tripura.
both the persons are from. And then the witnesses, 4 witnesses were examined.
Who are these witnesses?
These are witnesses. One is the assessor, person, then 3 of the witnesses, police.
NCB officer.
NCB officer. What about the independent?
No independent witness.
What is their status? They have not come.
No, see, we are in jail. It is their duty to bring the witness. So these witnesses are not.
But if records were called for.
Yeah.
Let's see.
10 copies. And in fact, what has happened to your lord? The court on their own has splitted up this. That was also not read by them. It was done in. There is a in a there. On 3-1.
Okay, what to do? Why not? 2 at 2?
Lordship, another half an hour there. It will take another 5 minutes.
At least we'll finish one.
This one we can finish.
Then the rest we'll see. Yes, what other methods we do not think will be possible. Nobody is willing to stay here. No, we will not do anything. We need to see all of you in the reference. No, others will be tomorrow, but no new matters.
Yes, but already
no new matters. Wherever in the list, we'll try to finish it up. At 2 will start, and rest tomorrow.
Supplement
That will come. That is the rest is.
Item 37 maybe later Wednesday.
Oh, wait for that. Wait for that. We are talking about this. We'll come back. Not that we will come at 2. Mr. Bakal, this case subject to what you argue will not hear further, Mr. Manna.
There is a record. Record big.
Otherwise 4.5 years.
No, even lordship, that period has to be, because lordship is already observed in the case time in Anastasia. Supreme Court has clearly stated that.
No, we'll see that. We'll of course see that.
Yes, definitely.
We'll of course see that, but subject to what you argue, then only we'll come back to Manna. We'll not waste time. Yes. Full stop. A copy of this MB furnished to the learned counsel.
And
Pay the cost.
next,
On payment of cost.
paper.
Who will pay the paper cost? Paper book.
This protested copy. Copy of protested. Copy of protested.
Raise will give okay.
Otherwise,
Okay, we have given free of cost.
Yes, madam.
Yes.
And in the next week, it may be.
And list thereafter in the next week.
Appraisal.
Yes, Kyle.
LC was called for. In the first page, there is a report of learned Petitioner. But here in this case, the accused were arrested on 9/12/2019. And thereafter, lordship, one other witness was examined on 13/10/2004 at 26. Report is of 14/9.
And what happened thereafter after 59?
One witness was examined on 13/10/2020.
13/10, na? How many witnesses remains?
Total 11 witnesses were cited by the division.
And how many examined?
4 till date. if there is a history in this case,
Hmm.
if there were 3 accused were named in the chart, final complaint. Till P1 2023, the process were issued against the counter accused, but didn't appear. And on P1 2023, the case was picked up. Then on 17/3/2023, copies were served to accused person. And on 31/3/2023, charges were framed against both the accused under section 20B, 2C, and 29 of NDPS. W1 examined on 31/5/2023.
What is the maximum punishment?
20 years.
Hmm?
20. Minimum 10, maximum.
Who are these witnesses?
40 for PW1 was the
Officer who is informant.
1, 3, and 4 were officers of the NCP. 2 was the special officer. One is the ex-general director, who is the superintendent of NCP. 3 is also teaching officer. 4 is IO. 4 is examined. 5 is examined. 6 is examined. 7, 11 was independent witness that have to be 3 officials of NCP.
Yes.
This is the position of the tribe. Further, here, both the accused, they are resident of West Tripura. Is near the Bangladesh border. There is every possibility. The bail is granted, they may jump the bail.
Yes, Manan, what you say regarding the second part?
But if another thing, recently, as many as 6 accused has been granted bail. Thereby, this one by out of that, 6 has been jumped up. Trial has been ended.
Yes, Manan, what you say about that part? How will you assure that you will be here? No, presumption, forget about. We are asking. Forget about their other case. How will you ensure that
Normally
you...
what happens whenever they have some kind of a feeling that might then there is a judgment purpose.
No,
Satendra Kumar, and he
Karni,
says that you have
tell us
very
what kind of condition you will suggest.
conditions, any conditions, very strict conditions should be given. Because in, I think, Ravi Prakash, that was also from another. So Ravi Prakash said that since the person is from another strict condition, that strict condition,
Local security, government employee.
well, these are best things. I think that would be the best way. Because Ravi Prakash,
Then appearing before the local police station every 15 days.
10 days, 15 days time, it should always and should have local security. Because yes, this is a one of the I think taken care of by this type of very stringent.
Just this is an idea. And what is anything you want to submit on merit? 37.
Merit part, your lordship, I was not submitting that day. Because I was basically on that day also I submitted 4.5. And that day I submitted the case of Ravi Prakash, and this case of more or less because the amount of ganja in Ravi Prakash is much more than the case here. And Ravi Prakash also, the persons are not from the same state.
You are relying on Mohit Agarwal, is not it, Mr.
Yes, Mohit Agarwal and 2 other judgments.
So when I said that, it asked, Ravi Prakash is basically a more or less similar. That is why I actually on that they referred to that. Because the in the merit here, the ganja here is 189, and in Ravi Prakash it is 247. The same the custodial period is much more here than the Ravi Prakash. And thirdly, your lordship, Ravi Prakash, the persons are from different states, and therefore the court has directed that there should be some stringent bail conditions. These are the only grounds I made on that. Secondly, since the Supreme Court has given bail to the ground of custody prolonged incarceration, and it militates the fundamental right of Article 20. That is the only case here. And otherwise, the trial is there. Trial will ultimately conclude, and whatever punishment is given, if he is found guilty, is there. But it's not found guilty. And your lordship, yesterday I think somebody has referred to Satendra Anti. Satendra Anti case, your lordship, there is a reference by the Honorable Supreme Court in one of the paragraphs. There is only 10 or 12% conviction in such. And one more thing, your lordship, with my learned friend has said, is the prosecution duty to complete the trial and prosecute or convict the person as early as possible. Now, they have violated certain conditions, they might have not done it properly. Now, this is where they will linger it for 10 years. The punishment is already there, and after 10 years, this person will be acquitted either by the trial court, high court. What happens, your lord? This is called prolonging. That is why the Supreme Court has all along prolong and prolong. When it is not fixed.
Okay.
With regard to Ravi. But when it comes to paragraph 2. Merit.
Yes.
The prosecution case appears to be that the police party while on patrolling duty on Santo at about on Nandapur road and Santo spotted one full body 12-wheeler truck bearing registration number 20 coming from Nandapur side at a high speed, and accordingly they chased and detained the truck at Kotagala Chowk and found 3 persons boarded in the said truck, including the driver. Eventually, 247 kg of ganja was recovered from the truck. The petitioner was one of the occupants of the truck and was arrested at the spot. He has been custody for more than 3.5 years. So this is the fact, and that we are informed that the trial has commenced, but only 1 out of 19 witnesses here in this case, Lordship. Although he was arrested in 2019, December 2019, Lordship, there were 3 accused. One was on the standard trial court issue process on different occasions.
Have you seen the orders?
And in
Have you seen the orders?
Lordship?
Have you seen the orders
Yes,
of the learned court?
I put on to some orders. Steps were taken, and in spite of that, he could not be apprehended.
So and so produced. Fix the next date on such and such. So and so produced from Hajar. Fix the matter on such
That
and
is the Lordship.
What is this?
But the process
Valuable, right?
process has
We
been.
will have to sensitize everybody.
Then another thing, Lordship. In this case, charge were framed on 31st of March 2020.
Why?
Lordship, because the case was split up and the copies were served.
Split it up on whose behalf? What is, you see your role of your engaged counsel. I'll tell engaged counsel. See the way the whole trial is conducted. The prosecution counsel will file a hazira and go. At the end of the day, one clerk will pass an order, so and so produce. Fix the next date on such.
That is to be serious. Serious.
Isn't it? We'll take personal note all this.
I think Lordship, the time has come. Take strong action against who is responsible.
Is it a way to proceed in a case where a person is inside jail, and it is you should be thankful to the learned judge that on his own it has been splitted up and started at least the trial at this stage. At least something has been done by the subsequent officer, and before him, absolute carelessness. We'll say this the careless.
But after framing of charge, 4 witnesses been.
Before framing of charge, they ought to have been released.
No, that is the Lordship altogether. I cannot comment on that.
No, you cannot comment, but we can comment. We will not pass any order, but we can very well comment from the record.
And Lordship, from Ravi Prakash, the Muslim, Lordship, yesterday also, argument has been placed.
No, we'll see. That's why we have seen. That's why we have taken 10 minutes going through the record. We are not saying that because 1 year, Tuttu will not lay down this kind of proposal. Yes, maybe 4.5 years may not be also. Sometimes we can say that, okay, you wait for another 6 months. It's not that only for because 6 months is there in terms of 436A will allow. It may not. We may ask you to complete it in 6 months.
But
there is no scope within 5 years in this case.
I will not comment on that.
We will have to. Is there any scope within 5 years?
If you want to fix the time frame, then the court is also found and the prosecution also found to trial with.
Problem is that, sorry to say, the interest of the prosecution is also, we have not seen that eagerness in continuing with the prosecution. We want the same eagerness that is we are getting from Mr. Kyle in objecting the bail.
No.
Same eagerness in the trial.
No, definitely.
Isn't it?
Yes, definitely. But
we agree that this is a law, special law.
If your Lordship sees the framing of charge, whether there was any delay on the part of the, that is to be.
What will to be ignored till framing of charge?
No, Lordship. Circumstances.
Anyway, we'll see. We'll pass this order.
Lordship.
We all have read these judgments are there.
Yesterday I have just one judgment that is also relevant for this case.
Which one? Which one? This bundle. Will not rely on all the judgments.
No,
we'll just summarize your argument. Let us not go deep into all this and affecting the trial.
1999, 9 SCC page 429. Yesterday I have submitted. Union of India versus Ram Samud Channel.
1999.
1999, 9 SCC page 429.
Can give me index.
Index already I have submitted the copies.
We have submitted copies, but we'll have to find it out. 2020, 1999, 3 SCC.
1999 9 SCC, page 4 to 9.
1999. Party's name?
Party's name is Union of India versus Ram Samuj.
Ram Samud, yes.
Paragraph 5, 6, and 7.
That there is no quarrel. That it is the 37. We'll have to have satisfaction.
Yes, that is.
But in view of the circumstances and positions, the Supreme Court in exercise of its power under 141 or 142 has laid down certain law, and that is also a law as equal, having equal strength as a law by the Parliament. So 37, in view of all these circumstances, will not use the word diluted, but that has been interpreted in a different manner in different cases. So that is also binding upon. We are not saying that it is an only on the period of detention we'll have to brush aside 37.
Yes.
It is not that.
That is our
It cannot be brushed aside. That is, we are aware of it. It cannot be brushed aside, but in certain cases, like that is of Mannan, suppose after 6 months, he will, in by virtue of law declared, he will almost have an indefeasible right. 430 trial is not complete. Yes. So whether for this court in the given facts should still wait for the 6 months. That is the issue in this case.
Another commission.
Yes.
436 days.
Yeah.
Lordship, it says maximum.
What the 436 says? Yes.
I'm reading.
Read it.
Maximum period for which an under trial prisoner can be detained, where a person has, during the period of investigation, inquiry, or trial under this sect of an offence under any law, not being offence for which the punishment of death has been specified as one of the punishment under that law, undergone detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offence, and that law, he shall be released by the court on the personal bond with or without security. Earlier, the law was that before until case, that in case of NDPS 436,
Not applicable.
not applicable.
Until say that
Yes,
same principle will apply. So therefore, your argument will be till, even if to apply until, you'll have to wait another 6.5 years, isn't it? Okay.
What I'm not actually, I have given this. I'm just giving it by very recent. It is this month of November by the here it says like Ravi Prakash, no specific law later, but it says just less than 2.5 years. So no use, because in the near future there is no question of complete. This is why I'm just for the sake of your law.
Okay.
But recently, with case of putting condition in one of judgment which I have not, I'll give to your where says that the GPS location should be shared with the novel, because in such cases it is very difficult to.
Okay, GPS is now shared. There are certain orders where you will have to have a independent mobile number,
Yes.
and you cannot change that number.
Yes.
And you cannot switch off that number.
Yes, sir. That
And if you want to change that number, you'll have to intimate the
in
police
the court.
so that
They
his location can be done, and he will not even switch off. Okay, that condition.
In the English, we have they put a band out and his location. Same thing is we are moving forward step by step.
If NCB says that we will provide a ban, seal ban, he cannot even remove. We keep that also condition.
And that ban should also be borne by the NCB officer.
That is also necessary. The witnesses.
At least they are the witness.
Another point with the NCB is that all the about 50% of officers are on deputy. The completion of the deputation they have posted. One of the case.
That we understand, but problem is that the officers and the system should remind themselves that this is not the end of my job. If I have this, I have my record statements are recorded under 161.
That is the difficulty, Lordship. Now we have prayed for the
Once-
online examination
Once
of
they arrest the person, they feel Now he will be there for
No,
5
they
years,
are
no
also
problem.
they are also happiness is that at least you are 5 years, okay. At least 5 years you are deterred. Their happiness is there.
Another point, Lordship, after Tufan Singh,
10%, 12%
About-
conviction.
Lordship, Lordship, it is not correct in case of NCB about
No, we will not go to all those facts. We are not Supreme Court. We will not take notice of all these facts until and unless facts and figure are before us.
just
Either we'll go to that what is the percentage, not that somebody were given by the Supreme Court without only condition that is 2.5 years. We are not having that power. We will have to see as if.
yes, Lord. That is our committee.
We will not say that it is 1 year ago. We will have to give out.
Yes, Lord.
Where is it?
Our commission to that effect.
Pass this order.
And the next is tomorrow. So this is 2:30.
Tomorrow, at any rate, we will finish this matter.
Sure.
No further postponing. We may have to sit for a little bit late. No additional matter for in this.
Sure.
Only this matter which are before us.